Hello, everybody, and welcome to this continuing legal education sponsored by the S.J. Quinney College of Law here at the University of Utah. I'm Leslie Francis. I'm Alfred C. Emery Professor of Law, and I'm delighted to welcome with me Katie Cox, who is a graduate of our wonderful law school and also a former fellow of our Center for Law and Biomedical Sciences. She's currently a staff attorney at the Utah Disability Law Center and the founding and current director of the Medical Legal Partnership here in Utah. So with that, we're going to get going talking about supported decision-making as a new option for actually everyone, including, it shows up very often for families here in Utah. So a little background about supported decision-making and where it fits. So it's a newly recognized important alternative to guardianship for people who might need help in making decisions, but as a way to preserve their dignity and independence to the fullest possible extent. Some other alternatives to full guardianship, just to put this in context, include, of course, a limited guardianship, powers of attorney for financial, healthcare, education. They can be springing to come into effect at a future point in time. They can be durable, persisting, despite the incapacity of the principal maker. There are other financial alternatives, including joint accounts, ABLE accounts for people with disabilities, trust accounts, Social Security representative payees, conservatorship for economic matters. In healthcare, we have advanced directives, we have default surrogate statutes. Advanced directives include both power of attorney for healthcare, what's called the living will. There's also a mental health advanced directive in Utah. People can just plan with the person at the center. People can share decision-making, working through possibilities with their physicians or with other loved ones. But we're here to talk about the newest one, so-called supported decision-making. So here are the basic structures of how supported decision-making works. It's about the individual remaining the decision maker, but with help. The individual decision maker is called the principal, who then selects someone to help them exercise decision-making capacity. Examples of how that might happen is gathering or synthesizing information, explaining difficult concepts, helping with financial calculations, or communicating decisions. We all use support all the time, so support arrangements may be informal, but now in Utah, we also have the possibility to create legally recognized support agreements, which may create new rights and duties for the person making the support agreement, the principal, for the supporter, who's also a party to the agreement, or for third parties, such as healthcare providers who encounter a patient with a support agreement. Why supported decision-making? People need guidance. but it puts the person at the center, increasing their self-determination, promoting their self-advocacy, maximizing their independence, enabling their continued ability to be capacitated decision makers, so there's no need to go to court for guardianship. I should say that doesn't mean lawyers are out of the picture, by the way, because lawyers, and much of what we're going to be talking about, is lawyers do a lot of important things helping with supported decision making. A little quick background. The Convention on the Rights of Persons with Disabilities, which the Human Rights Treaty that entered into force in 2007, requires states parties to provide persons with disabilities all the supports they need to exercise their full legal personhood. That's the sort of founding impetus internationally for supported decision making. The United States is not a state party to the CRPD, but nonetheless, supported decision-making has really taken hold across the country. There was a Virginia court decision recognizing it in the case of Jenny Hatch, a young woman with Down syndrome seeking to avoid her parents' overprotective petition for guardianship, and the Virginia courts granted her that wish. Texas was the first state. This is not a red state, blue state issue. Texas was the first state to adopt a supported decision-making statute in 2015, and we're almost at half the states and the District of Columbia with such statutes. So Katie is now going to take it over and talk about supported decision-making as legally recognized in the state of Utah.
Is that on? Yes, there it is. Thanks so much. It's nice to be chatting with all of you online. Yes. So supported decision-making was recently codified during the 2025 general session. You can find that at Utah Code Section 755701 through 709. I, as Leslie said earlier, work for the Disability Law Center. I have to give a shout out to the policy team at the Disability Law Center, and particularly one of my colleagues, Nate Krippus, who I think is present with us online, for just the incredible amount of work done to get this passed over a period of years. Nate was just integral to that work, and it couldn't have happened without him. And so he is really like the expert. I am sort of, through my knowledge acquired by Nate, I am here talking about this with Leslie today. So thanks, Nate. As I said, HB 334 codified supported decision-making agreements. It covers, how agreements can be created and terminated, what they include, protections that exist, and what that means for third parties. So we're going to do a deep dive there. Ultimately, the purposes of the Supported Decision-Making Act under Utah law, providing a principle. So when we talk about supported decision-making, a principal is the individual, right? The individual with the disability who is the principal making those agreements. So principal assistance in gathering and assessing information, understanding options, responsibilities, and consequences of a decision, and communicating those decisions for a principal if they want assistance with it. So that sort of, the supporter would be doing those things with a principal. It gives the supporter legal status, as would be specified in a supported decision-making agreement. So that is something that the supporter could, use as documentation, that kind of thing. That could be to access information on behalf of the principal, participating in discussions, et cetera. And then it also enables a supporter to assist in making and communicating decisions for a principal. To be clear, and we'll say this probably multiple times throughout the presentation, supported decision-making is about the principal, the individual with a disability, retaining their own decision-making authority and being the center of that, the guiding force in that. And a supporter is not a substitute. A supporter is a supporter. The principal continues to make their own decisions with or without those supporters. So let's dive in. So supported decision-making definitionally ultimately means the process of supporting and accommodating an individual in the decision-making process to make, communicate, and effectuate life decisions without impeding the self-determination of the individual. A supported decision-making agreement is simply an agreement between a principal and at least one supporter. So a principal may only have one supporter, they may have 3 supporters. Those supporters may help them with the same thing. Those supporters may help them with different things. It all depends on what that agreement says and what it is that the principal has outlined. A principal needs to be 18 years or older. They need to have a disability as defined under Utah law. You'll find that definition in section 701 of supported decision-making section of the code. And then that definition points to another code section, which is 26B 6801. And that definition points to the definition from the Americans with Disabilities Act. So we're talking about a pretty general definition. And then that they've entered into a supported decision-making agreement with at least one supporter. A supporter similarly needs to be 18 or older. A supporter cannot be being paid to provide support to the principal unless it is through caregiver compensation or as a sibling who cares for them. So there is a limitation there on folks who are being paid. They cannot have any substantiated allegations of abuse, neglect, exploitation. There can't be a protective order in place, conviction for harm of another, theft, financial crime, right? We're making sure that supporters are folks that aren't going to be in a position to take advantage of a principal. And then they need to agree to provide the support detailed in the agreement. So an agreement must be entered into voluntarily. There can be no coercion, no undue influence. An agreement should not be solicited. That's really important, that this is the principal, wanting to do this and moving forward with it. Both parties, the principal and the supporter or supporters, must understand the nature and the effect of the agreement. If the person seeking supported decision-making, so the principal has a guardian or conservator, that individual must be given notice and also an opportunity to participate in discussions related to the agreement, right? And then time to review, that's 14 days, and the proposed agreement to make sure that it doesn't sort of somehow infringe upon an area that they might have decision-making authority. So an agreement has to be in writing, has to have an effective date, has to designate at least one supporter, describes how the principal will use supported decision-making, the rights of the principal, the responsibility of the supporter or supporters, and any supports and accommodations that a principal needs to receive, and then any kinds of decisions in which a supporter cannot assist. It should be signed by the principal, each supporter, and a guardian or conservator if that's required, as we talked about in the previous slide, as well as 2 witnesses or a notary public. That sort of mirrors the ways in which Utah allows different kinds of documents to be signed. So that's why there's those 2 options, either 2 witnesses or a notary. And then that it describes any conflicts of interest and how they might be mitigated. And Leslie's going to dive into that a little later. Revocation and termination, also really important. Principal can revoke at any time. They just need to provide written notice to all the other parties. That's the same for a supporter. So either party can revoke at any time in writing. That can be done electronically as well. A supported decision-making agreement is also terminated when a principal dies, when it is revoked as noted above, when all supporters withdraw without new supporters being designated and subbing in. If the principal executes an overriding document, for example, a power of attorney, again, Leslie, I think is going to talk a little bit about that later on. And then if the court deems the principal to no longer have capacity, and that would be capacity in any area or in the area in which they're receiving support, right? Because when we talk about capacity, earlier, Leslie touched briefly on guardianship, right? In order to obtain a guardianship, an individual needs to be found incapacitated. If it's a full guardianship, that's going to be a general finding of incapacity. But if it's a limited guardianship, it's going to be incapacity in specific areas, right? So that would come into play as well here. And then as to a specific supporter, if that supporter no longer meets the requirements. So for example, if they begun to be paid for their services otherwise, that might be another reason. So the code section really, this is really the core of the interpretation of the law as you know, the legislature saw it. So the principal should be able to live in the manner in which they want to. They should be able to make decisions about accepting or refusing support, assistance, or protection, right? As long as it doesn't cause serious bodily injury. And again, that's as defined by Utah law, to the principal or harm to others. The principal should be informed about, and to the best of the principal's ability, participate in the management of their own affairs. We'll talk a little bit more a little later about issues of diminished capacity in general and specifically with regard to the practice of law. Principals should receive the most effective yet least restrictive and intrusive form of support, assistance, and protection when they're unable to manage their affairs alone. And their values, their beliefs, their wishes, their cultural norms, their traditions should be respected when supporters are supporting them. That's really paramount to a supported decision-making agreement. I think this one's still mine. It's still me. I work off paper for folks who do that still. Sometimes I need my paper version in front of me. So decisions or requests made or communicated by the principal under the terms of the support agreement are recognized and legally enforceable, right, as decisions made by the principal. So every agreement's going to look a little bit different. There are some forms available from some national organizations. Disability Law Center, we're also coming up with sort of a form that folks can work through, because that's going to be really important, right, for folks to have a model of what forms can look like. But agreements can look like, but they will be, they can look a number of ways as long as all of the components are present. The availability of formal support doesn't limit informal support, doesn't preclude judicial consideration of informal support in less restrictive alternatives to guardianship. Some of those we talked about earlier. So a person isn't limited to only receive support from their supporters, right? We're just talking about a supporter being this formalized agreement in a supported decision-making agreement, and the way in which they provide support should be the way in which that is defined in the agreement. Execution of a support agreement may not be a condition of participation in any activity, service, or program. So you shouldn't, have to participate in supported decision-making in order to receive, a benefit like a state service, for example. And the presence of a support agreement doesn't preclude the principal from making decisions without support, right? The principal is still able to make decisions without support. It just really outlines and formalizes what the support they want and need looks like.
I think I need the. Yeah. So I'm going to look at some things that supporters may and may not do, some things that principals get, and implications for third parties. So the statute is explicit that supporters can't coerce, exploit, unduly influence, step in and make decisions, sign for. So if you're a healthcare provider dealing with a person in a supported decision-making agreement, it's the patient who still gives the informed consent. And without the principal's consent, the supporter also may not go out and get other information that's not relevant to the support agreement, use information that they got through the relationship for matters other than support. So if you learn in the supported relationship that the principal has economic interests that might be affected by what somebody else does, you can't use that to help the somebody else. And the supporter can't delegate duties unless the principal agrees. A supporter who violates duties is liable to the principal, or if the principal has died, a successor in interest, for effectively restoration. Any amount required to restore the value of the principal's property to what it would have been had the support violation not occurred. And if there's a transaction between a supporter and a principal, when the supporter is in a position of trust and the supporter benefits, for example, purchase of a stereo or a car, that transaction is voidable by the principal unless, and the burden is on the supporter to establish that the transaction was fair to the principal. So one of the really important things about support agreements is that they have implications for third parties. The most likely third parties here are going to be healthcare professionals with whom the principal deals, and various financial, whether it's buying a car, taking out a car loan, dealing with a bank account, dealing with Social Security payments, any of those kinds of things. They're going to be potentially third parties involved. Third parties are supposed to recognize decisions or requests that are made in accord with the agreement, like a request for information, as the decision or request of the principal. So HIPAA defers to state laws, so that would be the case with respect to medical information. If a third party in good faith accepts or relies on the agreement, they can presume that the signatures in the agreement are genuine, unless they have actual knowledge they're not. They can presume the validity of the agreement, again, unless they have actual knowledge that the agreement isn't valid or that it's been otherwise revoked or void. And I think this will be really important to healthcare providers. They're not subject to civil or criminal liability, so no malpractice here, or professional discipline for giving effect to a provision of the agreement or following directions of the supporter in accord with the agreement. So if information is released in accord with the agreement, the provider wouldn't be subject to liability for a breach of confidentiality. If a decision made with support, consented to by the principal, is honored by a healthcare provider, such as a decision to refuse treatment, there wouldn't be liability. Now, here's a duty. If the third party has reason to suspect that the principal is or has been subject to abuse, neglect, or exploitation, must immediately report that to Adult Protective Services. And the statute is also explicit that no other reporting requirements are changed by this. And I would underline that it's any reason to suspect abuse, not just abuse by the supporter. So it could be abuse by another person that Adult Protective Services needs to know about. That, of course, might also lead to questioning the support agreement. So support issues, or the question about support, in my own guardianship defense representation through the signature program of the Office of State Courts and the State Bar, I encounter these kinds of situations where support might be particularly appropriate. One is the gradual wind down of life estate planning situation, particularly where dementia may be foreseen, suspected, or even creeping up. Another situation for potential support is far more stable. An adult, perhaps even a 17-year-old becoming an adult, with quite reasonable functioning but still needs for support. Jenny Hatch, the young woman with Down syndrome, is a perfect example of that. And think about people with fluctuating or relapsing, remitting conditions that might go through phases when they actually don't have capacity even with support, where they might have capacity with support, or they might not even need support at all. Some mental illnesses fluctuate in ways that have that presentation. These different situations present very different ethical and management issues for the lawyer dealing with the principal, or possibly the lawyer for somebody who might be a potential supporter. And here we are, this little commercial, 1.14, a very important rule of professional conduct. That's why you get ethics credit.
Indeed. So let's talk about legal ethics. So here we're talking about, I'm going to talk sort of more broadly about representing clients with different capacity, and then specifically we're going to dive into 1.14. So the first thing I'm going to sort of talk about is when we're working with clients who may have disabilities, who may have different capacities, the kinds of things that you're going to be wanting to assess to determine what your obligations are, right, under the professional rules. So if a client doesn't self-identify as being an individual with a disability or being an individual with maybe a capacity concern, right, some questions that you may need to sort of think about in assessing some of those things. Does the client act or do they talk in a different manner? Does the client seem unusually confused or preoccupied? Is the client's speech hard to understand? Does the client's vocabulary seem limited? Does the client have difficulty expressing themselves? Those are just some things you may need to be assessing sort of when you're meeting with a client and you're wondering sort of what are my ethical obligations from a capacity perspective. History questions can be really helpful in sort of gleaning some of that information without sort of asking some of those really direct, uncomfortable questions that I think we're often, unsure. We don't want to make assumptions. We don't want to, we want to be able to navigate that in a way that preserves a relationship. So did you have special services in school? So special education services, an IEP, 504, accommodations. Have you ever received mental health or DD services, right? Developmental disability services, so waiver services. Do you get any kind of Social Security check? Typically, that's going to be SSI or SSDI, right? Is there a guardian, representative payee, or power of attorney who helps you with your finances or your decisions? Those are going to be some of those helpful questions. I also always just want to put a plug in for some person-first language. That's incredibly important to me in my practice, and I think it's good to just revisit that, right? When we're talking about individuals with disabilities, putting the person before the disability, this is sort of best practice, right? There are certain individuals who choose to identify their disability that isn't not in a person-first way, or certain disability-specific areas where that's more common. For example, like I am autistic instead of I am a person with autism. But again, that's for sure what the person wants. So rule of thumb, start from that place of person-first language. So put the person before the disability. Describe what the person has, not who the person is. Reframe problems into needs. So just thinking about our language there. For example, say child or adult with a disability instead of saying handicapped or disabled. Has an intellectual disability instead of using the R word, which was medically, a medical terminology that we just don't really engage with anymore, right? She uses a wheelchair instead of wheelchair bound. A congenital disability or a brain injury instead of a birth defect or brain damage. Accessible parking instead of handicapped parking. So just thinking about those person first ways to talk about some of those things. Let's see. And then, so now we're gonna dive right into 1.14a. So when we're talking about the attorney-client relationship and determining what our obligations are with regard to diminished capacity, the model rule says that when a client's capacity to make adequately considered decisions in connection with the representation is diminished, the lawyer shall, as far as reasonably possible, maintain a normal relationship with the client, right? So we're not doing anything different. We're maintaining a normal relationship. Now, what is a normal relationship? That looks like effective communication. Your duty of loyalty is to the client, not to the guardian. So even if an individual has a guardian and they may have, or another decision maker, and they may, power of attorney, et cetera, and they may have a decision-making authority, and that individual might have a diminished capacity, your duty of loyalty is still to your client as an individual. When necessary to assist in representation, the presence of a third person doesn't affect your ability of attorney-client privilege. Or the applicability of attorney-client privilege. I encounter this a lot in my work, right? Folks who may want a supporter with them, a family member with them, a friend with them, maybe a service provider with them, as an accommodation, and that's typically how I sort of evaluate that in my work, is because that's an accommodation that's required in order for them to fully access my services and to understand what it is that we're doing, that doesn't break privilege, right? Because that person is there sort of as a tool. They're not a separate sort of person, but they're there as an extension of my client. And actually, I'll just stay here for 1 second. So the commentary in 1.14 suggests that the rule was needed because a client with a disability may be less able to monitor an attorney's performance, for example. Studies found that attorneys were spending less time interviewing clients with disabilities than other clients. And there tends to be a tendency to usurp decisions that are actually the client's decisions when we think we're in a situation where diminished capacity is implicated. And so that's why Model Rule 1.14a is really clear about, as far as reasonably possible, you still maintain that normal relationship. You just figure out how you need to do that, right? Now, there are occasions when protective action might be necessary. So now we're looking at Model Rule 1.14b. So an attorney can take protective action if they reasonably believe that all of these things are true. The client has diminished capacity. The client is at risk of substantial physical, financial, or other harm unless action is taken, and that the client cannot adequately act in their own interest. If all of those things are true, then an attorney would think about protective action. Now, what are we talking about when we say protective action? Some examples. That might look like consulting with family members, consulting with professionals, consulting with adult protective services, thinking about alternatives to guardianship or if some of those are already in place. And then appointment of a guardian ad litem or a guardian are some examples of other protective actions that could eventually be something that an attorney might look at. But I would say the first are probably, right, consulting with folks who know that person best, who know what that person's wants and needs are, who can help you to navigate their safety, and also that they're understanding what is happening and making those decisions. Some factors to consider. I was just sort of alluded to that a minute ago about the people who know them best. Really, the client's wishes and values, to the extent known, are what you really want to keep core, right? The client's best interests, but not doing that sort of substitution whenever possible, right? Because we don't want to be, if avoidable, substituting in a best interest situation. Preserving the client's decision-making autonomy to the greatest extent feasible. So navigating some of these things we're talking about to figure out how can we make sure that the client still has that autonomy to be making those decisions. Maximizing their capabilities with supports, for example, and getting information. And then representing the client's family and social connections, because those things are really important in order to know what it is that that individual wants and needs. And I'm going to pass it back.
So I might say I think it's possible that as attorneys, you're going to be dealing with clients who have supporters. And so that is a way to do the most you can to continue to maintain a normal attorney-client relationship, and those protections, such as the obligations of confidentiality and the privilege in particular, are really important to be aware of in this context. I would also emphasize one other thing that it's really important to be aware of is that the presence of a support agreement doesn't in any way change abuse reporting requirements. And this is an area in which I think there are going to be difficult conversations if you're representing a principal or if you're representing a supporter, actually, where there might be questions or a third party where there might be questions about abuse, about when and why to go to adult protective services. I know I struggle with the question of when I'm in a situation in which I think my client is suffering abuse and I need to report it, and I'm not at all sure from conversations with my client that they want it reported, and those are very difficult situations to negotiate. So this is actually our last slide, and I'm a scholar who writes a lot about supported decision making, and I've been in professional conversations at the National Institutes of Health about the use of supported decision making in research. I'm currently a co-editor of a special issue of the Journal of Law, Medicine, and Ethics on supported decision making and inclusion in clinical research. I'm also part of a collection coming out from the Petrie-Flom Center at Harvard on a variety of problems of decision-making with older clients and supported decision-making. So these are areas of concern that I've become aware of nationally that I don't know whether you'll encounter them, but that I think it's likely that we're going to have to continue to think about them, and I think they pose hard problems. So first of all, the interrelationship between a support arrangement and a power of attorney. So our statute says creation of a power of attorney revokes the support agreement. Well, that doesn't say anything about what creation of a support agreement does when there's a prior power of attorney. It also is very problematic in the context of a situation of fluctuating abilities. So let's say there's somebody in a support agreement at a time when capacity with support was clear, but then there's an anticipation that there may be a fall, so there's a creation of a power of attorney. Well, then that completely revokes the support agreement, maybe, but maybe the person will get better and want the support agreement. You know, you can see the issue with fluctuation. So you can create these instruments so that they talk to one another. The power of attorney can indicate that the support agreement continues. The support agreement can indicate things about interplay with the power of attorney, but all those things are going to need to be thought about and worked through. So the statute doesn't say anything about revoking prior documents. The support agreement might very well want to work through doing that, or creating a kind of toggle back and forth arrangement. Another thing to think about is an anticipated decline. And here I would just point out that dementias don't progress in the same ways depending on the kind of dementia. So something like a cardiovascular dementia, there might be a new event that's kind of, person falls off a bit of a cliff. Or there might be a social event that, like death of a spouse, or there might be a physical event, like a fall, that things get worse suddenly. On the other hand, with some dementias, it's a progressive but very slow decline. Thinking about the interrelationship between a support agreement and a power of attorney for those kinds of declines. I think something that's likely to come up, it comes up in the so-called living will, that what kind of care I do want or don't want, and power of attorney. So I'm quite sure it's going to come up with living wills and support arrangements. Is what if the living will has one of those my wishes documents, lists a set of wishes, but a decision being communicated pursuant to a support agreement doesn't seem to fit that. So we've got a person with capacity, so their living will is not in effect, but this suggestion is from the living will that they would have chosen something different than they're now choosing as the principal with support. How are we going to negotiate those kinds of tensions? I would also, and the last sort of open area that I would point out is people with Alzheimer's often want to participate in clinical research to help have things go better for others or for themselves in the hope of getting some kind of therapeutic benefit. Our statute specifically says support can't be made a condition of participating in a program or service. And as Katie said, that clearly has things like voc rehab in mind. But what about clinical research? One of the things I learned as part of this NIH roundtable was that there are research studies that want to include people with disabilities as the decision maker, but with support. And they want to require, these are, of course, it's voluntary whether you participate in the study, but they want to require support in order to participate in the study, in part because they don't want to have high dropout rates, which they might have if capacity changes just enough, but not enough to mean that the person isn't fully capacitated anymore, but not enough to keep the person from being capacitated with support. So they want to actually require people to have support in place. They also think that people may do a better job of following the clinical protocol if they have support. And I'm not sure, I don't think our legislator imagined that possibility. I don't know whether those kinds of studies are being conducted at the U, but I do think that's something that's likely to come up as people with support get entered into clinical trials, because one of the huge problems nationwide is that people with disabilities are far too often excluded from clinical trials.
Leslie, I have a quick question about that for you.
Yeah.
In the sort of the folks that you're hearing from, nationally that have sort of flagged this as a concern, when research, studies are saying we want that person to have a supporter as a condition, are they saying they want like a formalized agreement that would look like a supported decision-making agreement, or did they just mean like a person that has committed to being your supporter for like the length of the study? I wonder if that's a nuance.
That might be, yeah, I think that's an important nuance, and it might be enough. On the other hand, so one of the things the statute is explicit about is this is just a new toy. This is not something that takes away anything else. So it doesn't take away any of the informal, great support people get all of the time. But sometimes there are advantages to having it be formalized, including the rights and duties of third parties, the rights and duties of the supporter, and of the principal. So I can imagine it would go both ways. And it was actually, that issue was discussed. And there are some people, Nina Cohn, who's the reporter on the most recent, the uniform law on advanced care planning. She's the reporter on that, and she doesn't think supported decision-making should ever be formalized because she thinks that's going to undermine the informal stuff. I think that's a mistake, and she and I've dueled that out, and I'm sure the others, many supporters of supported decision-making also think that's a mistake. So another, and I lied about that being the last slide, another open area of concern is how to deal with anticipated conflicts of interest. So the statute states that the agreement must specify any such anticipated conflict of interest and how it's to be mitigated. Well, people are going to have to start thinking about what kinds can be anticipated and mitigation methods. There are statutes, supported decision-making statutes in some other states that explicitly suggest that the agreement can provide for third-party monitoring, that the principal could designate a third party to monitor the decisions made with support in financial matters, for example, is a good one of that kind. That's certainly something that could be proposed. So there could be an impartial person to have a look at a financial transaction that's being made with support. I worry about even potential conflicts of interest within the family. So if a child is a supporter of a parent and is also going to be the heir, that's a possible conflict, for example. And related to those conflicts, how do you select a supporter? Should it be somebody who's a bit more arm's length? Or what about life partners as supporters? I know estate planning lawyers all the time, spouses name each other as powers of attorney, but when you grow old together, you can also grow impaired together. And so that's not always a great idea. And so to how to think about that. And I also wrote a law review article about romantic partners as supporters and the kinds of potential conflicts that creates. So I'm actually a bit more of a proponent of having a little bit of distance between the supporter and the principal. But that's very much worth thinking about. One possible interesting arrangement would be to have the supporter also be the holder of the power of attorney. That makes when you go back and forth in fluctuating conditions, easier. On the other hand, does it make it more likely that suddenly the supporter will say, well, now I'm the power of attorney, and we no longer have support but supplanting? And the most fun conundrum of all, can you have support in selecting a supporter? That would have to be informal, of course. And, could the supporter give support in selecting themselves as supporter? Is that itself a conflict of interest? I mean, we're in a wonderful new world of how do you do the possible best of realizing the nothing about us without us goals of the CRPD, recognizing the full legal personhood of people with disabilities. Here's some great links compiled by the Disability Law Center, and Katie, thank you very much. And the slides will also be available. And I actually don't see any questions, which is why I gave myself license to talk a little bit longer. But if there are any, we are happy to answer them. At least I think I know how to read this, right? Because there's this little thing here that says pending. So, I think there's an interesting new line of business for lawyers here, which is representing principals thinking about support. Yeah, that's what I thought. Yeah. Nope. So, enjoy the rest of your day. Thank you all very much for joining us.
Yes, thank you so much.
And Katie, yes, thank you.
Thank you for the invitation.
Goodbye, everybody.